Thank you. In Citizens United, the Supreme Court held that corporations have the same free speech right as individuals to spend their money on elections. And just this past June, the Supreme Court held that corporations have religious liberty rights and allowed a bakery to refuse to sell a wedding cake to a same-sex couple. How did corporations come to have our most fundamental rights? In December 1882, former New York Senator Roscoe Conkling appeared before the justices of the Supreme Court of the United States. Conkling told the justices that corporations like his client, the Southern Pacific Railroad Company, were entitled to equal rights under the 14th Amendment to the Constitution. Although that provision said that no state shall deny to any person within its jurisdiction the equal protection of the laws, Conkling insisted that the amendment's drafters intended to cover business corporations too. Now, Conkling's claim was remarkable. The 14th Amendment had been adopted after the Civil War to guarantee the rights of the newly freed slaves, not to protect corporations. Conkling, however, had unusual credibility with the justices. A longtime leader of the Republican Party, Conkling had even been nominated to the Supreme Court himself. Although the Senate confirmed him, he declined the position. He was simply making too much money as a lawyer for the railroads. More than most lawyers then, Conkling was considered by the justices to be their peer. And when it came to the history surrounding the drafting of the 14th Amendment, Conkling's expertise was unparalleled. As a member of Congress, Conkling had been on the very committee that wrote the amendment, and he was the last surviving member of that committee. Conkling argued that while the nation was focused on the rights of the freedmen, he and the other drafters were also worried about laws that unduly burdened business corporations. It was for this very reason that the 14th Amendment used the word person. An early draft of the amendment had guaranteed the right of equal protection to, quote, citizens. Conkling argued, but that the language was later changed, he said, to include corporations, which were often considered persons for various legal purposes. As a result, Conkling argued, the 14th Amendment guaranteed the Southern Pacific Railroad Company the same right to equal protection of the laws as the former slaves. There was just one small problem with Conkling's account of the drafting of the 14th Amendment. It was not true. We now know that the language of the amendment had never been changed the way Conkling suggested, nor had any of the other framers and drafters of the 14th Amendment ever suggested or even implied that the amendment protected corporations. One of the preeminent figures in American politics had attempted instead to deceive the justices of the Supreme Court in an effort to win constitutional protections for the Southern Pacific Railroad. The justices eventually embraced Conkling's argument that corporations had rights protected by the 14th Amendment, and at the same time that the court was reading the amendment narrowly for racial minorities, upholding Jim Crow laws in the infamous Plessy against Ferguson, 1896. The court was reading the Constitution broadly to invalidate laws regulating businesses, such as minimum wage laws and zoning laws and child labor laws. Between 1868, when the 14th Amendment was ratified, and 1912, the justices decided 28 cases dealing with the rights of African Americans under the 14th Amendment, and an astonishing 312 cases on the rights of business corporations. The 14th Amendment, adopted to shield the former slaves from discrimination, had been transformed into a sword used by corporations to strike at unwanted regulation. Thank you.